happy to welcome participants from many other countries, and that's always fine. That's always something that we like at ICC, because as our name say, we are the International Chamber of Commerce. Today, we are going to have the pleasure to have three experts on board to talk about a very, very interesting topic for many of our members. And as I could see from the list of registries, not only people with a legal background or specialized in compliance, and that's very good because it actually concerned everybody that in the company. So to talk about how best to organize the process from alert, from whistleblowing to investigation, we have the pleasure today to welcome our friend, partner at EY, Frederik Verhasselt, and the corporate criminal lawyer Stijn De Meulenaer from Everest Law, as well as EY consultant Peter Leyman as well. And I think that it is now time, as I can see that many participants have joined us, to leave the floor to Frederik in order to introduce the topic of today. Thank you, Frederik. The floor is yours.
Thank you, Mathieu. Good morning, everybody, and welcome to the webinar From Whistleblowing to Court, organized by the Compliance Pro Register and the ICC, with the kind help of Everest Law and EY Forensic. I'm very pleased to see such a large number of attendants. Yesterday evening we had over 100 registrations. I guess there are still people coming in at the moment. It has been a while since our last live seminar, and I sincerely hope, and I guess that everybody hopes, to return back to normal over the coming months, so that we can restart live seminars followed by a small reception so that we can have personal interaction. Some weeks ago, we also launched a short questionnaire on internal investigations and the steps taken following a whistleblowing notification. At this moment, we have around 20 persons that have participated, and I would like to seize the opportunity to bring the questionnaire under your attention again. We would like to use the anonymized results as input for our interactions with the Ministry of Interior regarding a potential update of the law on private investigations. The webinar of today looks at the process flow from whistleblowing notification to investigation. And our first speaker is Peter Leyman. He's Executive Director at EY Forensic and specialized in leading complex investigations. As such, he will approach the issue from an operational point of view. The second part is given by Stijn De Meulenaer, partner at Everest Law and specialized in, amongst others, fraud litigation. And Stijn will tackle the legal ramification and pitfalls of private investigation. At the end of the seminar, there is, of course, time for questions. So, Peter, the floor is yours.
Yes, okay. Good morning, everybody. So, as already mentioned by Frederik, I want to give a brief introduction to the Whistleblowing Directive and to the practical approach of internal investigations. And I think that both topics are a bit related, because one of the elements of the Whistleblowing Directive is that you have to perform a decent investigation. So if we then have a look on this Whistleblowing Protective Directive, so that's actually an EU regulation that describes the kind of protection that you will give to a whistleblower in certain circumstances. And it also describes a bit the requirements for companies to set up reporting channels. So the first important question is actually what kind of breaches are in scope for this direction. So what kind of breaches can you report and will give you some protection under this EU directive. As you can see, it mainly concerns breaches against EU law or breaches against the financial interests of the European Union, which is quite logical because it's an EU regulation. But as you can see on the screen, it's quite broad, so it includes breaches against public procurements, but also against the corporate tax law, health and safety, but also GDPR is included. And then last but not least, also AML infringements are under the scope of the directive. And I think if you look at an internal fraud case, that very often there is some kind of money laundering involved, or it can be a breach against corporate tax laws. So anyway, your internal frauds are very often related to one of these topics and might come into the scope of the EU Whistleblowing Protection Directive. So as mentioned, this is an EU law that has to be translated by the member states into national law. For Belgium, this is not being done yet, but it should be done before the end of this year. And it can be mentioned that when translating it into national law, the member states have the freedom to add other breaches against their national laws. So that's something that possibly could happen also in Belgium. If we then have a look at how does then the reporting looks like, then you can see that basically we have a 3-level system that is foreseen in the directive. So the first level is the internal reporting within a company. So it's your standard whistleblowing hotline or your speak up system. The second level is the external reporting to competent authorities. So where you could report a breach somewhere to authorities. And the third level is the public disclosure, where, for example, you would make public a breach on social media or go immediately to the press. So there are some quite easy cascading principles for the 3 levels of reporting. So basically, a whistleblower has a free choice between the level 1 and level 2 reporting. So he can do it to the internal whistleblowing channel or the external whistleblowing channel. However, the directive mentions that the internal reporting should be encouraged. So actually, it would be preferred that you have an internal reporting and that people as a first choice use the internal reporting. The public disclosure, however, that's something that a whistleblower can only use when he has already used the internal or the external reporting, but no appropriate action was taken within 3 months. Or whether when he has some reasonable grounds that he really has to go out public immediately because there's an imminent danger to the public interest, or the interest is so large, or when he knows that when he reports internally or externally that there would not be any action taken and that it's too urgent to wait for that channel. So who has actually to be compliant with the directive? For companies with less than 50 employees, you don't have the obligation to set up an internal reporting channel. For large companies with 250 employees or more, they are required to set up an internal reporting channel, and this has to be done by the end of this year when the directive has to become transposed into national law, also in Belgium. And then you have some intermediate solution for companies that have from 50 to 249 employees. They have to set up an internal reporting channel, but they can organize that together with other companies to do some kind of resource sharing, and they get another 2 years to put this in place. If we then look on the requirements for your internal reporting channel. So here I have summarized the main obligations related to your internal reporting channel. So first of all, you can have a written channel that can be a full-blown online system where breaches can be reported, but it can also be a simple mailbox, or even people can send a letter by post. Or you can have some oral solution where people can call to a whistleblowing hotline. And also the whistleblower can request a personal meeting if he wants to explain his breach. Then very important, you have to safeguard the confidentiality of the whistleblower as much as possible and only disclose the identity of the whistleblower if it's really necessary and proportional. It can be mentioned that anonymous reporting, that's something that's not foreseen in the directive, which is quite logical. If you cannot protect a person, and this is actually the scope of the directive, the protection, if you don't know his entity, but it is optional and you can foresee an anonymous reporting in your internal reporting channel. Then very important is the duty of feedback. So once there is a breach reported, you have to acknowledge the receipt within 7 days. And you also have to provide feedback to the whistleblower on the actions that you have taken, the investigation and the outcome within 3 months. After 3 months, of course, the feedback can be that the investigation is still ongoing, but then it is expected that within 6 months you give an additional feedback on the outcome. Then you have some responsibilities regarding the governance of your internal reporting system, which means that you have to designate an impartial person or department to follow up on the alert and to do a decent investigation. So that has to be an impartial and a competent person. And the directive mentions, for example, that could be the compliance officer, HR, the legal counsel, the CFO, or an executive board member. And of course, this can also be outsourced to an external party. Then another requirement, which is quite logical and to be expected, is that you have to best data protection possible. So you have to secure the reporting channel, but also secure the storage of data afterwards on the breach, the actions taken, the outcome, and so on. So everything has to be GDPR compliant. Then you have a duty of information, which means that you have to communicate about your internal reporting system and process, but also on the fact that there are external reporting channels. And that's something that has to be made available not only to employees, but also to suppliers, service providers, and other business partners. Then one of the key elements is the protection of the whistleblower. So he will be protected against retaliation and against any liability. So he should not in general be liable for the fact that he would disclose some confidential information when reporting a breach. And the retaliation is very broad, so it can be a dismissal, but also missing a promotion, or even not receiving any training anymore within his company. And very important, there is a reversal of the burden of proof. So if a whistleblower would, for example, not receive any training anymore after his reporting of a breach, then it's up to the employer to prove that that is not related to the fact that he is a whistleblower. So it's not the whistleblower that has to prove the negative impact. It's actually the employer that has to prove that there is no negative impact. And then a final, but also very important point is the protection of the person concerned. So the person that is being reported as possibly committing a breach. The identity of that person has to be protected as much as possible. And he has also some basic rights. So like is for example, the presumption of innocence, the right to defend himself, to be heard, to have access to the investigation file and a fair trial. So actually you are obliged to do a decent and proper investigation in an objective manner, and that person is aware of that and is involved in the investigation. And that brings us by the second topic of the internal investigations. So I will discuss the flow of an investigation based on a standard methodology that most fraud auditors apply. And it's also an investigation methodology that we're for the moment formalizing with the Institute of Fraud Auditors in Belgium. So it's a 5-step approach. And I will make it a bit more practical by explaining it based on an actual case. So for the case, we are talking about an international construction company. So they have roofing projects with their headquarters in Germany. And they received a whistleblowing alert from someone from the accounting department in Belgium. And it's an alert regarding the Belgian CFO. And there would be some personal enrichment by the Belgian CFO. Some other background information that is available is that the Belgian board of directors, so from the Belgian entity, was composed of the CEO and the CFO. So both of them had powers of attorney to represent the company in Belgium. The international financial reporting towards the group CFO at headquarters was really only project-based, so they had to report on the costs and revenues of a project and the margins of the projects, but they did not at headquarter level have full details on the full accounting system and every single general ledger account. That was something that was not available. And as the Belgian accounting system was a cloud-based solution with only local user accounts, the group CFO did also not have access to the actual accounting system in Belgium. But next to that, so the general IT infrastructure, for example, like the file server or the mail service, that was managed by the IT manager at headquarter levels. So if we go then to the first step of the investigation methodology, that's actually the identify phase, where we would look at what is the kind of information that we have available, the allegation, the suspicions, and the currently available documents. Then you would look who is involved, what might be the potential fraud theory. Is there anything else from an information point of view that we already can gather at this stage? And that is really necessary for us to decide whether or not we want to proceed with an investigation. So for the case, the whistleblower mentioned that the CFO had a very expensive lifestyle, that large cash withdrawals had to be executed by the people from the accounting department at the request of the CFO, and also that there were some invoices that were processed solely by the CFO. Some additional information could be gathered at that stage. So on the one hand, it was one suspicious invoice, so an invoice that was processed solely by the CFO that was intercepted by the whistleblower. And then some background searches were performed on the CFO, where it was discovered that he owed 6 companies next to his management company, with quite some amounts passing through those companies. Whereas, he was normally full-time working for the company, and it was not clear what he would be doing in those 6 other companies. At that level, we didn't have any certainty whether or not the CEO would be involved, because they were working closely together and they were the 2 sole directors in Belgium. So the first fraud theory that you have based on that information is that there might be some fictitious invoices from the related parties of the CFO, and possibly also some theft of cash. So this was sufficient for the German headquarters to decide to proceed with an investigation. And a bit of background information from a legal situation to take into account was the fact that the CFO was engaged through his management company. So there was not an employer-employee relationship. So it was more a contractual relationship. So if we go to the next phase, that's actually the planning phase. In the planning phase, you would see what is our fraud theory and then identify how are we going to investigate that. So what would be the relevant data sources? What are the people that we have to include in this project? Who will perform the investigation, and what is actually our investigation plan? How will we tackle the investigation? So in this case, an external fraud auditor was appointed to perform the investigation, and it was decided to include the group CFO because he was responsible for the overall accounting, to include the group COO because he was responsible for the international operations and was more a bit supervising what happened in the Belgian entity from an operational perspective. And then, of course, also group HR and legal as it concerned a potential fraud. So then an investigation plan or memo was drafted where the background was described, what was known to date, and what is the objective. So the objective was to create transparency and identify potential irregularities. And then a description is made of the procedures that are planned. So that was first start with the kickoff interview, then safeguard and collect the data, understand the policies and procedures, certainly because it was mentioned that there was apparently an unusual flow of invoices managed by the CFO. Have a look at the cash transactions, identify the related party transactions with the CFO's companies, see whether there are other additional unusual transactions, review hard copy documents, and then analyze email and computers if that's appropriate at that stage of the interview, and then go for final interviews. So here to mention, it's really important to have a decent investigation plan at that stage, because it will afterwards allow you to demonstrate that you had a decent approach and that you looked at the proportionality of the steps that you're taking when performing the investigation. So the next step is actually initiating your investigation. It's not yet the execution, but the startup phase. Within a startup phase, you typically have some hidden actions, which mainly ensure that you make sure that data will not get lost, that you prepare for stopping any further detrimental actions, and that you make sure that when starting your investigation, everything is formalized and that you can actually, in a decent way, make the decision to start with an investigation. And then you would announce the investigation and perform an interview with the person concerned and really inform the person of that investigation and inform him about his rights during the investigation. So for this case, what were the hidden actions that have been taken? So first of all, a litigation hold was put on the mail server, which means that you activate the litigation hold that will ensure that any mail that is being deleted as from that point in time, that it will seem deleted in the mailbox of the users, but actually a copy of the deleted emails is preserved at the level of the mail server. It was ensured that there were sufficient backups of the mail server, the network folders, and even backups of computers to make sure that if things would get deleted, we could still go back to backups and recover data from those sources. Then everything was prepared that IT would be on standby for the day that the investigation would start, so that they were prepared to block the email accounts of the CEO and maybe also the CEO, that the network access would be deleted, blocked, their access badges could be blocked so that they could no longer have access to the buildings. Then as both the CFO and the CEO were directors in Belgium and the only persons that could legally represent the entity in Belgium, the necessary action was performed that the shareholder in Germany could make the formal decision to perform an investigation in Belgium, and that they could prepare for extraordinary board meetings to organize the dismissal of the CFO, and probably the CEO appoints additional directors, and then also inform, for example, the bank that they no longer had any power of attorney. So that's very important that you prepare that and that you actually have a decent approval and a signature that can really allow you to start the investigation within the company. Then subsequently, the on-site announcement of the investigation took place towards the CEO and the CFO. Then interviews were performed with the CFO and the CFO by the fraud auditors and external legal counsel. And then the CFO, well, he informed that indeed he was invoicing from his companies to the company, but that he could explain everything, but that he was willing to cooperate with the investigation. And then at that level, there was a mutual agreement between the company and the CFO to suspend his management agreement during the period in the investigation, and that he promised full cooperation during the investigation. Then the next step is actually the execution of the investigation, where you perform the investigation steps as described in your investigation memo. So we had a look at the cash transactions, and we noticed that there were on a yearly basis 600,000 euros of cash withdrawals that were supported by invoices from foreign companies. So for example, it were even invoices from companies in Africa, whereas the company totally had no activities in Africa at all. And they were paid in cash, which is really strange how you could pay an African company if you don't go over there in cash. Those invoices were also signed for approval by the CEO and the CFO. And there were some expense notes from employees to support the expenses with the cash withdrawals. we identified that from the related parties of the CFO, there were 800,000 euros of invoices on an annual basis, and they were processed through a manual flow. So the standard flow within the company was really based on a PO, and then an incoming invoice was scanned, matched against the PO, and then approved by the accounting department, as well as by the project manager on which budget the invoice would be allocated. But they had a separate flow with an invoice being booked immediately into the accounting system and immediately being paid. But that was a flow that they should only apply for the management fee invoices of the CEO and the CFO, because they wanted to keep that a bit discreet within the company so that not everybody would see that. But the CFO also applied that flow for the invoices from his companies. But we saw that also those invoices had been signed by the CEO for approval. And in that unusual manual invoice flow, we also identified on a yearly basis 300,000 euros of invoices from an interior shop. And actually, the company was quite small from an administrative perspective, so there were not at all goods for that amounts available within the building of that company. So the CFO was cooperating with the investigation and provided some documents. So on the one hand, he had a lot of signed declarations from family members and friends from him that stated that they helped him out because he was very, very busy with services for the company. For example, his 80 years old mother provided a written declaration that she helped out with reviewing legal contracts with suppliers, and that she also helped out with the customization of the ERP system. And there was a bunch of declarations from his family members and friends with similar statements. Then he provided agreements with his companies and the company itself, and all those agreements were also signed by the CEO. And he provided a statement of the owner of the interior shop, who stated that the goods had been ordered by the company and had been delivered at the house of the CEO. So additional interviews were performed with employees, and it appeared that everybody within the company really trusted the CFO, and that they provided him with blank documents with their signature, and that the CFO could use those documents to provide their expense notes. And also the CFO provided blank documents with his signature on it, so that the CFO could prepare his expense notes. Additionally, they also mentioned that their bonuses were made with cash payments, so that actually it were immediately net bonuses without any taxes being paid, and that they were aware that the CFO made a little bit of fake expense notes to support those cash extractions with the blank documents with their signatures that they provided. However, based on what has been reported, those cash bonus payments only amounted to 100,000 euros a year, which could not explain the full amount of 600,000 euros of cash withdrawals on a yearly basis. And everybody mentioned that the expert services from the related parties were never delivered. For example, the contracts were really standard and never had to be reviewed. The ERP system was a cloud-based system that they just used off the shelf without any customization. So it seemed that that was all fictitious, and also the invoices from the foreign companies, nobody could explain that those foreign companies would have ever delivered any goods to the company. When looking at the computers, then it appeared that all the invoices from the foreign companies, the expense notes, and also the agreements that were afterwards signed by the CFO existed in a Word format on the computer of the CFO. And we also saw that instructions for the invoices that were afterwards issued by the interior shop, so what should be on the invoices from a description level and also from an amount, those instructions have been sent by the CFO towards the interior shop. So the final phase then of the investigation on the next slide is the closing of the investigation. where you, in the closing phase, would validate your findings. So to see that everything is supporting by documents that prove what you're stating in your report. Then you draft a first version of the report. And then at that stage, you would present your observations to the person concerned during a final interview and give him the final opportunity to provide feedback, additional explanations, and maybe additional documentations, and that you process that into your final report. Then assess what actions might be taken, for example, dismissal or a criminal complaint. Finally send your report to bodies and persons authorized to make the decisions, disclose to law enforcement or external stakeholders if relevant, and then archive everything. So very quickly, in this case, the CFO in the final interview kept with his previous statement, so that everything has been delivered, actually, that his family members did provide services, that the documents were signed by the CEO, that blank documents with signatures never delivered, and that the CFO had seen everything that he signed, and that he had documents on his computer that it could be explained that it was just because he was helping out with preparing documents, or that he first did receive invoices in a Word format by email and then printed them out. So this has been added as explanations or statements to the final report, but still based on the various explanations from the employee and what was found on the computer, the headquarters decided to terminate the agreement with the CFO based on grounds of fraud. A seizure of the assets of the CFO has been initiated and executed, and a criminal complaint has been filed. So after that, the police also started with an investigation with our report as a starting point. And during a house search at the house of the CFO, they found some blank documents with the signatures of the CEO and employees. So, however, the CFO mentioned that they did not exist, but it was found at his house. Large cash amounts were found at his house, so also supporting the suspicions that actually the cash transactions, cash withdrawals went to the CFO itself. Then over the years, large accumulated cash amounts had been deposited on the bank account of the CFO. And during interrogations with the police, when it became clear that it was very serious and that there was a formal investigation, his family and friends withdrawn their statements that they performed services and confessed that they have just written those statements at the request of the CFO, but that it was completely fictitious. Then the owner of the interior shop confessed that actually he had a lot of black money and that the invoicing was some kind of money laundering scheme. So invoices were issued to the company. They were paid with bank withdrawal, bank transfers. So it was really then official money towards the interior shop, and his black cash was then transferred in cash to the CFO. And the foreign companies also confirmed that the invoices were fictitious. So it was very clear that there was a lot of fictitious invoices with wire transfers to the companies of the CFO, and a lot of cash withdrawals that immediately went to the CFO. So I want to wrap up with some key takeaways. So as you can see, whistleblowing, you should rather look at it as an opportunity than an obligation, because it really helps to discover fraud, and in practice it's still the #1 source of detecting fraud, still even now when it's not an obligation yet. It is important to involve experts when you perform an investigation, so persons who are impartial and competent. And you always have to keep in mind your end objective. So at the end, you want to be able to recover goods, file a complaint, and then certainly pass the legal test. So you have to do everything in a proper way, but that's more the topic of Stijn, who will discuss that within a couple of minutes. Then internal investigations can accelerate the subsequent external police investigation. So if you have already done an internal investigation and provided a report to authorities, they will have to redo some of the work, but they already have a starting point, and it allows them already to take some actions, for example, on seizure, looking at bank accounts, contacting banks. So there is quite some interaction between internal and external investigations. And yeah, the synergies are really important, and it is actually recommended to start your internal investigation, but then also file a complaint and cooperate with the police. So that's the most interesting approach to have a big success. So those were my key messages. So I think I now can transfer it to Stijn for the legal part of this presentation.
Okay, thank you, Peter. Good morning, everybody. I'm glad to see that there are 91 participants, which is a lot on an early summer day or full summer day in early spring, actually. I'm glad that so many people are interested in fraud investigation and whistleblowing, and I'm going to take you with me in the coming 40-45 minutes into some legal topics. I'm a lawyer specialized in fraud mitigation, fraud prevention, fraud detection, assisting fraud investigations also. And maybe Julie, you can show the content which I want to elaborate with you. I took mainly two big issues. The first issue is starting from the principles, legal principles of private investigation, where I want to give some attention to what is the right on privacy, because the right on privacy is, as from my experience as an attorney working often in fraud investigation case, one of the maybe the most important question. Where does privacy start? Where does privacy end? What can we do in a private investigation? We have no public mandate like an investigating judge or a public attorney. How do we manage the right on privacy? Where I'm going to talk to you about the right on privacy as such, right on privacy in a company, and where I already tell you that the answer will be to elaborate everything which is necessary in a fraud policy. We'll talk about it later. Second topic, well, you can still give this this slide, yes. Legal status of the fraud investigator. I'm going to talk about it maximum 10 minutes. It's a topic where there is lots to say, but we have limited time. And then finally, we will draw some attention on, I chose 3 legal pitfalls. There are a lot more legal pitfalls in our experience, but I decided to talk about some questions which are often raised in our practice. Can we have access to emails? Are there limits? Are there conditions which have to be met with? First. Secondly, open sources. There is an idea of everything which can be found in open sources on the internet can be used unlimited. Is this true? And then finally, a very difficult balance, dismissal for serious cause versus the private investigation is the last topic I want to raise with you. So first, the principles, where I start with the right on privacy and the question how to manage this. First of all, I always start when I'm talking about the right on privacy as an attorney. That's quite logic with the legal basis. And this is not what often is taught. This is not the GDPR, or not before the GDPR, the so-called Privacy Act, the Wet op Verwerking Persoonsgegevens. This is not what grants you a right on privacy. The right on privacy is actually elaborated in international and conventional, Belgian constitutional legislation. On an international level, you have, first of all, the European Convention on the Human Rights, and more in particular, the Article 8 of it, which grants in 2 sentences, it's not more than that, which says, first of all, everyone has the right to respect for, in general terms, for his private life, for his home, so domicile, your house, and correspondence, which is as well old-fashioned correspondence, a letter as electronic communication, email, but also WhatsApp, Skype, and so on, which is covered actually in very general terms by the European Convention on Human Rights. Everyone has the right to respect, therefore. Second phrase, an interdiction for public authorities to interfere into your private life, but of course with exceptions. Exceptions when they are in accordance with the law. So you need a legal basis, you need a law in order to permit a public authority to breach your privacy. And a legislator cannot make no matter what law, this law must be necessary in, according to the European Convention, necessary in a democratic society. And then it is elaborated in what conditions this must meet in the interest of national security, public safety, or economic well-being of the country. And then important for fraud investigation or private investigation, prevention of disorder or crime. It goes further with protection of health or morals, and finally also relevant for us for the protection of the rights and freedoms of others, also the freedom of the rights of a company, of a client, which is or thinks to have suspicions that there is a fraud in the company. Second international legislation which is applicable is the International Covenant on Civil and Political Rights. Article 17 there, it's more or less a mirror on the European Convention. It says no one shall be subjected to arbitrary or unlawful interference with, and then again in broad general terms, privacy, family, home or correspondence. And everyone has the right to the protection of the law against such interference. So this covenant does not say that an exception can be made by law, but it says that the law must guarantee, must protect your privacy. And both of them are translated in the Belgian Constitution, which is the next slide. The Belgian Constitution, I have not translated it because it exists formally only in Belgian, French, also German, but I forgot, I'm sorry. I hope there are no German participants. But the text says that everybody has the right on respect of his privacy and family life, so similar terms as the international legislation, except in the cases and under the conditions as determined by law. So two things are important. Everybody has respect on his privacy life, again, broad terms, but there is an exception when this is determined by law. There has to be a legal basis, there has to be a law which gives you the opportunity to breach the privacy and which says under which conditions this can be done. Most known example is the example of, for example, an investigating judge. An investigating judge has, of course, as we all know, the possibility to do a house search, to arrest a person, which is a very big privacy intrusive activity. He has a legal basis. The Code of Criminal Procedure in Belgium allows him to do this. This is the legal basis for privacy, the right on privacy. Second question, is privacy also applicable within a company? Years ago, a lot of clients asked me often, well, is this so? We have a company, our people, our employees are considered to be here for professional reasons. We give them a laptop, we give them all the possibilities. It's all a professional context. Is there such a thing as privacy? Well, yes, unfortunately, for those who would like to see it otherwise, there is also a right on privacy in a company context. Already in 1992, almost 30 years ago, the European Court for Human Rights, in the case of Mr. Niemetz against Germany, has elaborated that the home has to be accepted as extending to business premises. The idea behind it is that most of the people, or a lot of people, make also on the professional, on the work floor, make private relations. Some of your colleagues are your friends. When you come home from holiday, you show them your holiday pictures. This is private and has nothing to do with the professional context. So there is a right on privacy on the work floor. Is this right on privacy, and you can show the next slide, Julie, is this right as strict as in a pure private context in your household? No, it is not. It is a contextual right that needs to be judged, taking into account the concrete circumstances of the case. So this means that a judge, of course, will have to take into account that he is in a company, a professional environment where the privacy is not that high as in a pure private context, but this is the difficulty, the border between this private and professional aspect within a company. This is what makes it difficult to deal with it. European Court for Human Rights since a long time uses 3 principles in order to elaborate whether breach of privacy is legitimate or illegitimate. And to be legitimate, these 3 principles have to be met with are the principle first of finality, secondly of proportionality, and thirdly of legality. I explain them slide by slide. First principle is the principle of finality, which means you have to have a right purpose, a right aim. We can refer to one of the slides before, the slide where we elaborated the Article 8 of the European Convention of Human Rights, where, for example, for private investigation is referred to the interest of national security, openbare orde publiek, or the prevention of disorder or crime, which are, according to the European Convention of Human Rights, legitimate purposes which a legislator can use to make a law that allows you to breach into someone's privacy under certain conditions. So for private investigation, I think there's no much discussion on the fact that the aim, the purpose of fraud prevention and fraud detection is as such okay. So there is no problem with the principle of finality normally. Second principle is the principle of proportionality, which means that an investigative measure, a private investigative measure which has been taken, needs to be necessary. What does this mean? Well, this means actually that for every private investigative measure that you take, and that is what we always advise to our clients, to companies who are doing fraud investigation or to fraud investigators, that for every investigative measure you have to take into balance the facts you are investigating on the one hand and the measures you are taking into account on the other hand. And for every measure you have to make the exercise, is there a less privacy intrusive way in order to obtain the result, in order to obtain the proof, the potential proof of fraud? So this is a case-by-case exercise which has to be done in a private investigation, and we always advise to document, to motivate into your report when you make an investigative measure, certainly a measure which goes quite far in terms of privacy intrusion, that you motivate, that you document well in your report why you took this measure and not a less privacy intrusive measure. Third principle is the principle of legality, which used to be the most difficult one, actually, because while we are here in the context of private investigation, it's not a public investigation. In a public investigation, this is all regulated by law. You have the Code of Criminal Procedure. You have other acts which give government institutions or persons working for government competences to make an investigation. This is not the case for private investigation. There is no such thing as a private investigative act which allows you, which gives private investigator certain competencies. And then we refer again to the basis of the privacy, the right on privacy, which is the Belgian constitution in Belgium, which says that in order to do a privacy breach, that you need a legal basis. It needs to be regulated by law. So long time there was discussion, well, how do we deal with this for private investigation? Well, it is actually the former Privacy Commission, nowadays the Commission for Data Protection, that gave in 2012 already, from its own initiative, a recommendation, because it's got a lot of questions according to or regarding privacy in a professional context, in a company context. And the Privacy Commission actually said, well, we can use the Article 16 of the Labor Agreement Act, which is actually the general act in labor law, which allows an employer, which gives the employer a legal mandate to exercise surveillance and control on his personnel. So the Privacy Commission says, well, this is the legal grounds which in a relation employer-employee can be used in order to execute private investigation. Does this allow an employer to do whatever he wants? Can he go as far as he wants because he has the right to control according to Article 16 of the Labor Agreement Act? Well, the Privacy Commission says no, and this is what we apply when we advise for companies. We did this for some banks already, for example. And the Privacy Commission says you have to specify this in a policy which needs to be transparent, known to the employees, which needs to be enforceable. They have to know what you are up to in a company, and which has to be embedded within the limits of exceptions and guarantees provided by the law, amongst which it still refers to the Privacy Act, now the GDPR. So actually, how do you do this? Well, it has to be in accordance with, according again, the Privacy Commission. It has to be in accordance with normal company management, and in accordance with all other relevant legal and also regulative provisions within the company, amongst which collective labor agreements, and then it refers, we will talk about it later, to the CAO number 81. So important, you can give the next slide, important for the principle of legality for private investigation. It is okay as long as the company has a transparent and enforceable rule that allows a concrete way of privacy intrusion. When the company says, look, we have made it enforceable and transparent to our employees that in this company it is possible that, to give an example, that the internet traffic is controlled. So the principle of legality can be met in this way. In practice, how do we do this when we are asked to assist a company in implementing this recommendation, if you want? Well, we start, of course, by looking what does exist already. Is there a labor regulation? Is something described in the labor agreements? Are there guidelines, formal, informal, in no matter what way? But we mostly end up, or we try to end with the editing a fraud policy, where we gather everything, where we bring everything together, and where we says, look, this is a fraud policy, which we will, once it is agreed in the company, which we will make transparent and enforceable, or which the company has to make transparent and enforceable towards its employees. And what do we describe and determine in this fraud policy? Well, first, finality, the aim and scope of private investigation. what does the company provides? Is this only for fraud, or is this also for example, personal relational aspects, sexual harassment, etc.? Secondly, who is responsible for this within the company? Which entity? Is there a fraud department? Is this the internal audit? Are there specific persons? When there is a whistleblowing system, we also describe the whistleblowing system, and this will be something which will in the next year or years, which where the fraud policies will have to be adapted, I think, according to the European legislation to be implemented by the Belgian law. We also describe important which competences, what can a private investigator do based on this Article 16 of the Labor Agreement Act, and we describe the procedure for an interview, for drafting report, data retention, how long can you hold data, which is in accordance with the GDPR, of course, confidentiality, and so on. We do this especially based on the recommendation of the Privacy Commission, the former Privacy Commission, which only talks about the relation employee-employer, but of course by implementing a fraud policy and by making this fraud policy also applicable in for administrators, for directors, for consultants which are working in the company, you can of course go broader and make within your company an enforceable fraud policy which gives you the opportunity to do a lot more than without having thought about it on beforehand. Second topic I want to raise with you is something which is the last months more and more on topic, because Annelies Verlinden, the Minister of Internal Affairs, announced that she wants to renew what we call the Private Detective Act, the Wet op de Privé-directieve, and that she wants to make an act on private investigation, an act on private investigation. So a question which is relevant in the sector of private investigators since 10 or 15 years is a private investigator, is a fraud investigator falling under the application field of the Private Detective Act? The question is almost always yes, and I'm going to be very short here, but what does the Private Detective Act provide? It starts from activities, and it says a list of activities enumerated by this law. When any natural person which is doing this usually and against payment for a client is doing these activities, he has to be considered as a private detective. That is the way the law works. So for internal auditors who are only ad hoc, eventually doing a fraud investigation, they can play with the term usually. They are not usually doing this, but a real fraud investigator, even internal or external, doesn't matter, who is doing this against payment, loan, or an invoice when you are an external one for a client. Well, he falls very quick under the application field because of the activity which is set on the slides, collecting evidence in order to determine facts that might give rise to conflicts between persons or might be used to end such conflicts. So might give rise, which means that almost any fraud investigator which has a mission to investigate whether there is fraud, logically is collecting evidence in order to determine facts. That's his mission. That, of course, he doesn't know yet whether there is fraud or not. He has to investigate this. This might give rise to conflicts is very logical. So he falls under the application field. But there is a big but. There are a lot of exceptions in the Private Detective Act. First of all, the Act and some royal decrees of the Act elaborate some professions which are accepted, which do not fall under the application field. Some legal professions, attorneys, bailiffs, notary publics, but also experts, not only experts appointed by the court, gerechtsdeskundigen, but also experts whose profession is explicitly regulated by law. What does this mean? Well, every expert profession like accountants, réviseurs d'entreprise, where there is a legal basis, whether there is a law which regulates this profession, they do not fall under the application field of the law. But again, a fraud investigator like, for example, Peter and Frederik with EY, they are no accountants, they are doing 100% fraud investigation, maybe combined with prevention, but they do not fall because of their profession under the exception. What is then a second possibility, a second exception? Well, this is an exception which is until today, yes, you can give the next slide, is an exception provided in a royal decree of 1994. This royal decree, which is not detailed at all, the discussions in the government that decided on this royal decree are very limited, but nevertheless, the royal decree says that the Private Detective Act is not applicable as far as information is only gathered with the interested party. So when you are investigating with the interested party, you do not fall under the application field of the law. The question is, of course, what is the interested party? There is no definition, nobody discussed about it when this royal decree was voted. So we have to interpret. The narrow interpretation is, of course, and that's logic, and at least this is the interested party, the target of the investigation, the subject of the investigation. He is, of course, he or she is, of course, an interested party, the CFO of the example which the case which Peter talked about. But the interested party might also be the client. The company is the client which asks a private investigator to do a private investigation. Nobody can say that he is not an interested party. This is actually a broad interpretation, which is also supported by the Institute for Fraud Auditors, which as long as you are only gathering information with the interested party, amongst which the client, so as long as you are doing your investigation intramuros, within the company, you can do this. Well, there's a lot of discussion about it. There is unfortunately no clear jurisprudence which says this is correct or this is not correct. But there is, and that's the next slide, and there is a pre-project of Private Investigating Act or Investigation Act, which is prepared within the Ministry of Internal Affairs, and where Minister Verlinden announced that this in this government, by this government, this will become act. We will have to see, because the next government also said this, but at least there is a text. This text makes for sure that the interested party interpretation will end, because it's very clear there that the interested party is only the target and not the client, not the company, which means that all 100% private investigators not mentioned under another profession or not falling under another profession will need a license, a private investigating license. Other consequences, well, the profession will be more regulated, which for me is positive, which means that the do's and don'ts will be clearly set out. Now already in the text of the pre-project, you can see that there is a clear procedure for interviewing, for reporting, etc. The GDPR is also met with in this pre-project. I believe that the fact that this becomes, again, actual, that this is also because the text of the GDPR is implemented in this pre-project. Another consequence, all private investigators will have to follow an education. Nowadays, to become private detective, that's an education of 2 years, which is limited, which is really focused on private detective acts, the Sherlock Holmes, I always say, and also on the private investigators. So we hope, with the IFA, we try to convince the Ministry the Minister of Internal Affairs, that the education needs to be adapted. And last but not least, which is already today in the Private Detective Act the case, the mandatory declaration to the public prosecutor will remain. So private investigator which starts an investigation that can lead to the fact that there are criminal offenses, and that will often be the case because fraud is almost always a criminal offense. Well, then he needs, before starting his investigation, to inform the public prosecutor. This is also a point of attention where the IFA wants to talk about with the Ministry of Internal Affairs. Why? Because a lot of missions from or executed by private investigators serve to look to within the company to solve the question: is the suspicion of fraud, is this correct? Is there something? Do we need to go further? Do we need to lodge a criminal complaint? Do we need to dismiss somebody for serious cause or not? When the text does not change, this will mean that every private investigator will have to start by informing the public prosecutor, and then of course it's out of your hands what will happen. So this is not what is wished by the sector. Second topic, and I have to hurry up a little bit, 3 legal pitfalls. I will be quite short. First of all, a question which we often get. We want to look into the email, of course. Nowadays, when you want to, the case also where Peter talked about, you want to see the emails. You want to gather proof by controlling the emails. Is this legally possible? Well, first of all, there is an article 314 bis in the Code Penal, strafwetboek in Belgium, the criminal code, which is actually elaborated in the Code Penal in order to avoid that telephone communication could be intercepted. This says that recording private communication or telecommunication during transmission is forbidden when you are not a recipient, when you are not taking part. So this forbids to interfere in the communication. So the moment, but on applicated on email, this does not forbid a lot, because an email is sent in a fraction of a second. This means only that in between sending and receiving, in this fraction of a second, you cannot interfere. Once it is in an inbox, it has been sent, and Article 314 bis does not forbid to use an email once it is in an inbox. But Article 124 of the Electronic Communication Act does, unfortunately, in this context, forbids this, says that the submission of existence of information of all nature sent by electronic way is forbidden for non-recipients. So the legal answer is no, you cannot, but there is luckily a but. There is a possibility, and that's on the next slide. There is a collective labor agreement which has to be implemented, and this is important also from a preventive aspect within your company. If you don't have implemented the CAO, the collective labor agreement 81, you cannot use it. But the collective labor agreement 81 is a labor agreement which allows a company that has implemented to have to take knowledge or to have access to as well internet traffic or email correspondence of employees. The CAO says that an employer can only do this in certain circumstances. I only listed the ones which are relevant for private investigation. Protection of economic, commercial, or financial interests of the company. Well, it's logic when a company believes that there are suspicions of fraud, that the company is a victim of fraud, this falls under the financial interests of the company. So this is again the principle of finality which needs to be met. Legality, I already explained you in the Article 16 of the Labour Agreement Act. And there is a procedure that provides that when you implement this, when you bring this to the Work Council, etc., when you implement the CAO, that you can take knowledge of email and internet correspondence in 2 stages. Collective, you have to be transparent in a general way to your employees and mention them that in the company it is possible that you do email control under certain circumstances. That's again the fraud policy where we insert this. For some issues, you also need, before entering into data, you need to inform the recipient. Luckily, not for the protection of economic, commercial, or financial interests. So this means that you only have to respect the collective stage for private investigation. You have to, but you have to make it transparent. And then we come again with the fraud policy, where we do this also for other purposes. The Privacy Commission has given in a recommendation some practical tips. I'm not also always that warm for their tips, but they give 2 possibilities to work with emails in a company. And they say, well, or you allow the double use of email. You allow your employees to use private and professional emails, or the email for private and professional purposes. But then we advise that you work with private folders or flags, that you oblige them to use a private flag or a private folder. Everything which is saved in other folders or which is not flags can be considered as professional. It is a way of dealing with it. The second possibility is more severe, simple. Forbids all personal use of emails, which is often difficult in companies where a private use through the years has been accepted. What is a critic on the recommendations of the Privacy Commission? That's of course that a real fraudster which wants to commit fraud will of course or delete or puts all correspondence under the private flag, and then you cannot enter or not control this as an employer. Second topic, second legal pitfall. Well, I can be quite short about it. I will not read the case of the Labour Court, which is an example of it. The question here is, can we use open sources? Yes, of course you can use open sources, but you have to be careful with it. I give the example of social media. This was a case where the Labour Court in Brussels needed to decide upon the use of data on a Facebook page of an employee which has been dismissed for urgent reasons or serious causes. Where the Labour Court decides to use what is also in the jurisprudence of the European Court of Human Rights, often used, the reasonable privacy expectation. Thus, somebody can expect that his privacy will be breached due to his behavior. Well, the court here, when you will read it, you will see. The court says, well, the public data on the public Facebook page, where you don't, for those who know Facebook, where you don't have to be friends of the Facebook member. Well, that's an open source which everybody can use. There, the privacy expectation of the one who puts data on his Facebook page on the public part, he might expect that somebody, that also his employer or also other fraud investigators, for example, gets this information. On the other hand, what is not allowed according to the Labour Court, that is accessing the friends part, at least when you are not a friend, and especially this was not the case here, but I got the question already several times. Can we create a fictitious account in order to become friends with a target of an investigation? I think you have to be very careful with that. But you can use open sources, but think always about a reasonable privacy expectation. And then the last legal pitfall, and then I will end so that we still have some time for questions. That's the dismissal for serious cause. I already mentioned it. Article 35 of the Labor Contract Act gives the possibility to the employer to end immediately a labor agreement when there is a serious deficiency that makes all professional collaboration between the employer and the employee immediately and definitely impossible. There is, and that's why I mentioned it with the legal pitfalls, there is a very strict procedure that has to be followed, which you all know, I think, but which in relation to private investigation needs to be considered. There are two terms of 3 days. As soon as you get enough knowledge, and that's important, enough knowledge of the facts, then the one who can decide upon the dismissal for serious cause needs to do this within a term of 3 days. So after the knowledge of the facts, within 3 days, and watch out, a Saturday is also a working day in this act, you need to give the dismissal for serious cause. You don't have to motivate yet. There you have the second term of 3 days, also with the Saturday as a working day, 3 days after the dismissal. Then you have to give the motivation. Very important that you are as broad enough, because if there is a discussion before the labor court, you only can motivate the dismissal on the motivation used in your letter. Motivation grounds which only rise later on. You go further in your investigation and you find more grounds are not accepted anymore. Yes, next slide. Last slide is that. Well, in relation with private investigation, what is important? Luckily, the jurisprudence accepts that the start of the first 3 days term is the moment where there is sufficient and certain knowledge. And it is accepted that an investigation or a fraud audit prolongs the term of 3 days. It is accepted that a company has the right to elaborate whether there is fraud, to give a mission to a fraud investigator to see, is there fraud, is this suspicion real? Of course, don't abuse it, don't work on an investigation during a year or 2 years, then you will have difficulties. But the fact that you ask an investigation is a good argument to say, well, the first 3 day terms only started at the end of the investigation, when we became certain that there is a fraud committed. Watch out with provisional reports. I already often saw this. Luckily, it was not always seen by the employee, but well, you are working as a private investigator for your client, for the company, and you want to show them where you are. The client is curious because fraud is something people want to know. Where are you? Do you find evidence? And you are sometimes you have the feeling, well, I will draft already a provisional report. Watch out, because when this provisional report becomes known to the employee, and when he can argue that already at that moment there was enough evidence to dismiss for serious cause, and you still waited till the final report, then a lot of chance that you missed your 3 days term, and social courts are very severe in the application of these terms. So that was what I wanted to give you from the legal point. I think we have now 10 minutes for Q&A, and I saw there are already some questions raised in the chat box or in the Q&A box. I don't know how we go further. Peter, the first is for you.
You're looking at the Q&A, I think.
The Q&A, yes, that's right.
Yes, so this was the question: what happens or what can be done in case the CEO or the CFO decides to dismiss the compliance officer in the course of the investigation in order to block it? So I think in the future situation when the whistleblower directive would be in place in Belgium, then you would have the option, after the internal reporting, to go to some external reporting. And if that would not result in anything after 3 months, that you can go for the public disclosure. So you have additional pressure outside the company to report the breach, if it falls under the scope of the Whistleblower Protection Directive, of course. I think in practice, what we see nowadays, that in such cases, you would see whether there are maybe independent board members that you could inform about the situation, or even inform the shareholders. So someone who is at least has a bit of an independent role within the company, or which is an independent stakeholder where you could report an issue to, and then they can take further action. So that would be, I think, in a brief way, the response to that question.
Okay, Peter, I see there are 3 more questions. The second and the third question is certainly for me. First, the second question: what does the law jurisprudence says about when talking about principle of finality? The question to be raised is how we can define public order or national interests. Would you have any examples inside Belgian law about this? Well, it's you are right. This is the question, but there is not much discussion on this. The finality and jurisprudence. We in relation with private investigation, we don't see a lot of issues on the finality. I think it is important. You don't have to define public order or national interest. I think it is important that you define that you are, and that is also what is met with in the GDPR, for example, that you are doing this with the aim, with the purpose of prevention or detection of fraud. This is enough. This is literally in recital 47, I believe, with the GDPR provided prevention or detection of fraud as an aim, a purpose which is allowed for GDPR. So I think this is also okay for private investigation in general. Second question also for me. What does the law says about recording a conversation, phone call, or in presence when you are part of the interaction? Is it allowed for one to record its own communications and use it as a proof? Well, the Article 314 of the Criminal Code, nor the Article 24 of the Electronic Communication Act forbids this, so it's not forbidden. When you are when you are a participant of a call, you can record it. For an ordinary conversation, there are even no strict. It is not a criminal offense. That's the first question you have to raise. Is this a criminal offense? I don't think so. Second question is, of course, privacy related. The privacy expectation, where I talked about. Can somebody expect in a certain circumstance, can somebody expect that a conversation is recorded? This is a question regarding privacy, and that's a more difficult one. Then it all depends on the concrete conditions, but it happens, and the jurisprudence accepts it when it's good elaborated, let's say. Then does today GDPR impose restrictions on private investigations? Yes, GDPR elaborates who needs to be the controller, who needs to be the processor, data retention period. I did not mention it because we had not enough time for this, but there are GDPR restrictions, and in the new pre-project of Private Investigation Act, this is also implemented. But as long as this is not the case, I advise that you implement it yourself in your fraud policy, if you have a fraud policy, of course. with respect to implementation time frame of the WB directive, I think that's a question for Peter. Peter?
Yeah, so that would be 2021. So it has to be transposed by the Belgium as a member state by the end of this year, and then it would be applicable as a national law. Yeah, of course, there's still nothing yet in Belgium, so that's actually the date set forward by the European Commission, and I would expect that Belgium will comply with that, but it will become, yeah, a very short notice, of course, for Belgian companies, as it takes a lot of time for the translation into national law in Belgium. Then for the calculation of the number of employees, I don't think that anything is foreseen on that yet, so that's something that will be, yeah, more explicitly mentioned when it's translated into a Belgian law. And then regarding the sectors to which it will apply, so it's applicable for any organization. So as well for the private sector as the public sector, it's only for companies active in the financial markets that the rules are a bit more strict. So they cannot be excluded if they have less employees. So they have to be fully compliant anyway. Okay, so the key success factors for the fraud investigation. I think there were a number of key success factors. So on the one hand, this was actually the message given by the headquarters in Germany that they really wanted to perform an investigation, and that they suspended the CFO during the investigation, and that yeah, enabled that all employees were very cooperative and came forward with everything that they knew. Then what has been really useful was the very quick action on the seizure of the assets of the CFO. So once the report was available, action was taken for that, and it allowed to ensure that actually assets could be recovered from the CFO. And then certainly that everything was documented very well as from the beginning, and that legal counsel has been involved from the beginning, so that it was really well prepared, that the appropriate approvals from shareholders and board members were there that could really authorize in a decent way the investigation, that it was documented what was the cause for the investigation, what was the objective for the investigations, what were the steps taken, and that there was a step-by-step approach, and that it's not the first step looking at emails, but that you do it very step-by-step based, and really consider what could be the impact for the person concerned for every step that you take, and that you explain why it is necessary at that stage. And that was quite important, because the subject of what has been found out was severe enough for further action, but the CFO in the subsequent court cases was really rather playing it on the form of what happened than actually the substance. But due to the decent documentation that was available as from the beginning, and the involvement of a legal counsel, it really passed the legal test at the end. And then finally, what was being really useful was the cooperation with the police, because you see a lot of things that are very interesting internally, but sometimes to really close the circle, you need to have access to some information that can be only discovered during a police investigation. And then the whistleblower, it was not anonymous, so it was a person from the accounting department. And then the protection, it was mentioned within their policies that they should be protected, and actually the name has not been disclosed to the CFO from the actual whistleblower, and it has not been necessary afterwards to disclose the name, because we collected documents that could prove everything. And I think certainly the fact that the CFO was suspended during the investigation was also very interesting to protect the whistleblower at that stage.
So I think we're at the end of all the questions. Peter and Stijn, I would like to thank you very much for the very clear explanations that you gave. And well, I wish everybody a very sunny afternoon and hope to see you on one of the next webinars or live seminars. Thank you.